My name is Ed Sharkansky and I'm an experienced criminal defense attorney. These are my 5 answers to the most frequently asked questions I receive by my new clients. First, when will I get my license back? A license suspension for a drunk driving case usually begins upon arrest with either a breath test failure or a breath test refusal. Breath test failure suspensions are much shorter than breath test refusal suspensions, and the length of your suspension depends on your history of drunk driving convictions. If you're found not guilty, any suspension could be terminated early, but if you're convicted, an additional suspension will incur. The circumstances for everybody's license suspensions are unique, and only an experienced drunk driving defense attorney can help you figure out when exactly you'll be ready to drive. Next, will the jury think I'm guilty because I refused the breath test? The answer is simply no, because the jury will never hear that you refused the breath test. In Massachusetts, you have a right against presenting any evidence against yourself. Therefore, you have a right to say no to the breath test, and the jury can't hear about it or make any inference that you're guilty because you said no. There's simply no mention of the breath test being offered or that you refused in front of a jury. So, the jury will never think you're guilty simply because you said no to the breath test. Third, will the jury think I'm guilty because I refused to perform field sobriety tests? And the answer is the same as the breath test. You have an absolute right not to present evidence against yourself. Therefore, you should say no, and the jury will never hear that you were offered field sobriety tests and that you chose not to perform them. Fourth, the police report sounds so bad. Should I just plead guilty? Let me tell you, I have handled hundreds of drunk driving cases, and the police reports always sound helpless. The jury will never see the police report. And in fact, there are facts within that police report that will never be presented to the jury from the witness stand. Items like breath test refusals, field sobriety test refusals, certain pieces of evidence that have been eliminated at pretrial hearings, all of which will be excluded at trial and make the police report sound much different than your actual trial will sound from the witness stand. The best thing you can do is have an experienced drunk driving defense attorney review your police report, because with his experienced eyes, he'll know exactly how that police report will sound in front of a jury. Finally, what will happen if I'm convicted? Well, the sentence you'll receive if you are convicted depends primarily on your history, specifically your history of drunk driving convictions. Obviously, the more convictions you have in the past, the more significant the penalty will be. For first and second offenders, it's likely that you'll receive a program, whether it be an outpatient program or an inpatient program, along with some probation and some follow-up aftercare. For third or more convictions of drunk driving, you have now a felony conviction and you must be sentenced to jail. Anywhere from 150 days to a house of correction, up to a 2-year minimum penalty and a maximum of 5 years in state prison. In addition, the license suspensions associated with drunk driving convictions can become overwhelming if you're a repeat offender. An experienced drunk driving attorney can help you not only avoid the conviction in the first place, but minimize the penalty you might receive in the license suspension that follows. My name is Ed Sharkansky and I'm an experienced drunk driving defense attorney, and those are my 5 answers to the most frequently asked questions I receive from my new clients.